So today's video is about crimes against public order. In order for you to understand the crimes against public order, because there are at least there are more than 20 crimes enumerated in this chapter, I grouped them into 7 so that you can easily understand or you can easily get a grasp. So these are the rebellion, sedition, illegal assemblies as opposed to illegal associations, Kuda, direct assault as opposed to indirect assault, serious disobedience as compared to simple disobedience, tumults, evasion of service of sentence, and quasi-recidivism. So in the next slides we will be discussing the crimes under each of the boxes. So let's start with Article 134, which is rebellion. Rebellion is an important matter in the bar examination. So please take note of Article 134. What are its elements? Number 1 is that there be a public uprising and taking of arms against the government, and the purpose of the uprising or the movement is either, letter A, to remove from the allegiance to said government or its laws the territory of the Philippines or any part thereof, or any body of land, naval, or other armed forces. Another purpose is to deprive the chief executive or Congress wholly or partially or any of their powers or prerogatives. So okay, it's a long sentence, but actually the main purpose of rebellion is to overthrow the government. If you will write that, the examiner will already consider that, because the main purpose, and that is one of the things I want you to remember about rebellion, is the main purpose is really to overthrow the existing government. You want to supplant the existing government. Another area I want you to consider when you study rebellion is you cannot absorb other crimes, or you cannot complex rebellion with other crimes. Like for example, there's homicide with rape with homicide, that is common, but with rebellion you cannot designate a particular crime like rebellion with murder or rebellion with serious physical injuries. The complexing of with other crimes is not allowed in rebellion as long as it is in furtherance of rebellion, in the commission of the rebellion, so you only have that rebellion as a crime committed. Article 134-A is about Kuda. Again, another favorite topic. This is always asked in the bar examination. Usually the questions are compare or differentiate rebellion from Kuda. So aside from looking into the purpose, you have to look also at the participants in the offenders of the particular crime. So here the elements are: number 1, the offender is a person or persons belonging to the military or police or holding any public office or employment. So take note of this. This is a very important element. This what distinguishes Kuda from the other crimes. Number 2 is it is committed by means of a swift attack accompanied by violence, intimidation, threat, strategy, or stealth. Number 3 is the attack is directed against the duly constituted authorities of the Republic of the Philippines, or the attack is directed against the military camp or installation, communication networks like the globe, smart, public utilities, or other facilities needed for the exercise and continued possession of power. And number 4 is again the purpose. The purpose of the attack is to seize or diminish the state power. Sedition. So these 3, sedition, Kuda, rebellion, and sometimes treason, they are usually asked, the examiner usually would like to ask you about the differences among the 4. So just take note always of the purpose and also the offenders. Okay, and then take note also that the 3 are crimes against public order, while the treason is crime against the national security and the law of nations, which makes it a which makes it different because it has a extraterritorial application. So here in sedition, the elements are: number one, the offenders rise publicly and tumultuously. Number two, they employ force, intimidation, or other means outside of legal methods. And number three is the offenders employ any of those means to attain any of the following objects. So again, this is the purpose as differentiated from rebellion, because in rebellion, the purpose there is more of political end, like you want to overthrow the government. In sedition, the purpose is, aside from political end, it is also for social end. Number one purpose is to prevent the promulgation or execution of any law, or you want to prevent the holding of any popular election. Number two purpose is to prevent the national government or any provincial or municipal government or any public officer thereof from freely exercising its or his functions, or to prevent the execution of any administrative order. Number three is you want to inflict any act of hate or revenge upon the person or property of any public officer or employee. And number four is to commit for any political or social end any act of hate or revenge against private persons or any social class. And the last purpose is to despoil for any political or social end any person, municipality or province or the national government of all its property or any part thereof. So just take note that in rebellion, the purpose is for political end, and here in sedition, it's for political or social end. That's one of the distinctions actually. So we go now to Article 135, who are responsible for rebellion or insurrection. Number one is any person who promotes, maintains, or heads a rebellion or insurrection. So these are the leaders. And number two is any person who, while holding any public office or employment, takes part therein, engaging in war against the forces of the government, destroying property or committing serious violence, exacting contributions, or diverting public funds from the lawful purpose for which they have been appropriated. And aside from the leaders, you also have the participants. The participants are also liable for rebellion. Any person merely participating or executing the commands of others in a rebellion. So here I want you to look at rebellion and sedition, because in rebellion and sedition there are specific crimes, but what makes it different is in rebellion, the conspiracy to commit rebellion is already punishable, as well as the proposal to commit rebellion. This is supposed to be rebellion. And in sedition, only conspiracy to commit sedition is punishable. However, take note, the proposal to commit sedition is not punishable. Again, inciting to rebellion is already punishable, and likewise, inciting to sedition is also punishable. So these are the specific crimes that I want you to remember again in the rebellion and sedition. I did not already include the elements of the same because I noticed that this the crimes enumerated here are not usually were not asked at all in the bar examination. Maybe they were asked only if there is a conspiracy, or if there a crime like proposal to commit sedition exists. So those are the crimes that are being asked. Aside from that, the elements, you cannot see them in the bar examinations. Article 145 is violation of parliamentary immunity. So there are two ways of committing violation of parliamentary immunity. And number one is by using force, intimidation, threats, or fraud to prevent any member of the Congress, or what it's called before, the National Assembly, from, number one, attending the meetings of the Assembly or any of its committees, subcommittees, the CONCOM, or the committees or divisions thereof. Or you will prevent a congressman from expressing his opinions or from casting his votes. Another way of committing violation of parliamentary immunity is by arresting or searching any member thereof while the Congress is in regular or special session, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor, or that is 6 years. So you all know this because you can find this also in your constitution. Illegal assemblies. Illegal assemblies is asked also in the bar examinations. Usually, they are asked as to differentiate from illegal association. So there are two ways also to commit this crime, illegal assemblies. One way of committing is any meeting attended by armed persons, and the purpose of which is to commit crimes punishable under the revised penal code. So the elements is there is a meeting, a gathering, or a group of persons, whether it is in a fixed place or moving, and the meeting is attended by armed persons. And the purpose is to commit any of the crimes punishable under the revised penal code. The second way of committing illegal assemblies is there is a meeting which the audience, whether they are armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or assault upon a person in authority or his agents. So the elements are there is a meeting, a gathering, or a group of persons, whether in a fixed place or moving, and the audience, which makes it different from the other way of committing illegal assemblies, are armed. They are armed or they are not armed, is they are incited to the commission of particular crimes, and these particular crimes are treason, rebellion, sedition, or direct assault. So who are the persons responsible for illegal assembly? So those are the organizers or the leaders of the meeting, and the persons merely present at the meeting. Illegal associations, on the other hand, is associations that are totally or partially organized for the purpose of committing any of the crimes punishable under the code. Likewise, they are committed by associations totally or partially organized for some purpose that are contrary to public morals. So, who are the persons liable for illegal association? So, these are the founders, the directors, and the president of the association. And number 2 are the mere members of the association. Okay, before we discuss the direct assault, indirect assault, I want you first to remember who are the persons in authority and who are considered as agents of person in authority, because this topic is always asked in the bar examination question. So you have to remember who are those considered as person or persons in authority. So Article 152 is the answer. So a person in authority is any person. So who is that person? That person can be an individual or a member of some court or government-owned or controlled corporations, or he is a member of a board or a commission. So that person is directly vested with jurisdiction. What does it mean? What does it mean to be directly vested with jurisdiction? It means that you have that power and authority to govern and execute the laws. So, in Article 152, it also mentioned that barangay captain or the barangay chairman, as we call them now, are considered persons in authority. Likewise, in Article 152, it says that teachers, the professors, and persons charged with the supervision of public schools or private schools, as long as they are recognized, are also considered persons in authority. So those are your persons in authority. How about an agent of a person in authority? Well, an agent of a person in authority is any person who, there are 3 ways, he has that direct provision of the law, or through an election, or by appointment by competent authority, he is charged with the maintenance of public order, as well as the protection and security of life and property. So this is your policemen, the sheriff, for example. So these are the people considered persons in authority and agents of persons in authority. Please take note of Article 152, often asked in the bar examinations. So we'll now go to direct assaults, favorite topic in the bar examinations. You have to study this carefully. If you can look at the bar examinations, you'll see a lot of questions coming from Article 148, and there are two ways of committing, again, direct assaults, and that is number one, without public uprising. Without public uprising is opposed to the rebellion, because in rebellion there is a public uprising. So without public uprising, by employing force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition. So what are the elements? Again, number one, the offender employs force or intimidation. Number two is the aim of the offender is to attain any of the purposes of the crime of rebellion or any of the objects of the crime of sedition, and there is no public uprising. Another way of committing direct assault is without public uprising, by attacking or by employing force or by seriously intimidating or resisting any person in authority or any of his agents while engaged in the performance of the official duties or on occasion of such performance. So the elements are number one, the offender here, he makes an attack or he employs force or he makes a serious intimidation or he makes a serious resistance, and the person assaulted is a person in authority or his agent, and at the time of the assault, the person in authority or his agent is engaged in the actual performance of official duties, or letter B, he is assaulted by reason of the past performance of official duties. Take note of number 3 because I saw a bar examination question relating to number 3. There was this accused who was found guilty by the judge, and he was sentenced to a particular crime, and after serving his sentence, he was already released and free. But after 1 week, he returned to the judge and killed the judge. So what is the crime committed? So one of the crimes committed there is direct assault, because the judge was killed by reason, or there was an attack or there was a force employed upon the judge because of the past performance of official duties. And number 4 element is the offender knows that the one he is assaulting is a person in authority or his agent and in the exercise of his duties. And lastly is that there is no public uprising. So there are two kinds of direct assault actually, that is the simple assault and then the qualified assault. So what are the instances wherein the assault is considered qualified? Number 1 is when the assault is committed with a weapon. Number 2 is when the offender is a public officer or employee. And number 3 is when the offender, it means that the accused is a public officer or employee. The accused is not a merely private person. And number 3 is when the offender lays hands upon a person in authority. So Article 149 is about indirect assaults. Indirect assaults. In indirect assaults, a person in authority or his agent is the victim of any of the forms of direct assault defined in Article 148. A person comes, here is another person, he comes to the aid of such authority or his agent, and the offender makes use of force or intimidation upon such person coming to the aid of the authority or his agent. So here, actually in indirect assault, you are a stranger. You just want to help a person in authority or an agent of person in authority, and yet you are being assaulted also by the offender. So that's the essence of indirect assault. Study carefully Article 149 because again, like what I said, Article 148, 149, favorite topic in the bar examinations. Article 151, the serious disobedience as opposed to simple disobedience, also asked in the bar examination but not as often as Article 148 or the direct assault. So, in resistance and serious disobedience, the following are its elements. A person or his agent is engaged in the performance of official duties or gives a lawful order to the offender. The offender here resists or seriously disobeys such person in authority or his agent, and the act of the offender is not included in the provisions of Article 148, 149, and 150. Another crime enumerated here in Article 151 is the simple disobedience. Here, an agent of a person in authority is engaged in the performance of official duty or gives a lawful order to the offender. The offender disobeys such agent of a person in authority, and such disobedience is not of a serious nature. So I have here the list of which are considered public disorders, that is the tumults and other disturbances of public order, alarms and scandals, and delivering prisoners from jail. So what are considered disturbances of public order, or what it is called tumults? So if you cause any serious disturbance in a public place or in a public office or in a public establishment, so you can be charged with tumults. And second is the interruption or disturbance of public performances, functions, gatherings, or peaceful meetings if the act is not included in Article 131 and 32. Third is making any outcry and tending to incite rebellion, sedition, in any meeting, association, or public place, or displaying placards or emblems which provoke a disturbance of public order in such place, and bearing with pomp or with grandiose the body of a person who has been legally executed. So those are considered tumults. Alarms and scandals. Take note that it is alarms with S and scandals, and when you put this crime or when you answer this crime, it is alarms and scandals. You cannot write only scandals, or you cannot only write alarms. So double S, alarms and scandals. So what are considered alarms and scandals is, number one is if you discharge any firearm, firecracker, rocket, or other explosives within any town or public place calculated to cause alarm or danger. Number two is you instigate or take an active part in any charivari or other disorderly meeting offensive to another or prejudicial to public tranquility. If you disturb the public peace while wandering about at night or while engaged in any other nocturnal amusements. If you caused any disturbance or scandal in public places while intoxicated or otherwise, provided Article 153 is not applicable. So alarms and scandals, also a topic in the bar examination. Please study. Okay, so again, Article 156, favorite also in the bar examinations, delivering prisoners from jails. Ang hirap, no? Delivering prisoners from jails, but it only means that you help a person to escape. Usually, they are asked together with evasion of service of sentence, delivering prisoners from jails, and infidelity in the custody of a prisoner. in the custody of a person. So these three are usually asked: what is the liability of the police officer, what is the liability of the person who helped, and what is the liability of the detainee. So here the elements are: there is a person who is confined in a jail or penal establishment, and another person or a stranger, here considered the offender, he removes such person or helps the escape of such person. So that is called delivering prisoners from jails. So take note, delivering prisoners from jails. So this is now the last tranche of your crimes against public order, the three kinds of evasion of the service of sentence. So evasion of service of sentence by escaping during the term of his sentence, evasion of service of sentence on the occasion of these orders, and other cases of evasion of service of sentence by violating the conditions of conditional pardon. So first is, again, Article 157. I told you that this is often asked in the bar examinations alongside with the infidelity in the custody of the prisoners and delivering prisoners from jail. So these three are parang magkasama. So the elements are: number one is the offender is a convict by final judgment, and he is serving his sentence, which consists in deprivation of liberty, and he evades the service of his sentence by escaping during the term of his sentence. Article 158, this happened during the Bagyo Ondoy. There was this proclamation that all the convicts should return to their cell because of what happened. So that is your example. The elements is: the offender is a convict who by final judgment who is confined in a penal institution, and there is disorder resulting from conflagration, earthquake, explosion, similar catastrophe, or mutiny in which he has not participated, and the offender evades the service of his sentence by leaving the penal institution where he is confined or on the occasion of such disorder or during the mutiny, and the offender fails to give himself up to the authorities within 48 hours following the issuance of a proclamation by the chief executive announcing the passing away of such calamity. So to relate, that is what happened during Ondoy. There was this proclamation made by the president that all convicts or all prisoners should return to their cell. Article 159 is the violation of conditional pardon, actually, or they call it other cases of evasion of service of sentence, but it is a violation of conditional pardon, and the elements are: the offender was a convict, he was granted a conditional pardon by the chief executive, and he violated any of the conditions of such pardon. Article 160 is a bar favorite, a bar question area. It is a bar matter, it's a bar area. Usually the questions here are, you differentiate quasi-recidivism with habitual delinquency, recidivism, reiteration. So those are the questions. So you will be discussing recidivism as opposed to habitual delinquent in Book 1, but not here in Book 2. So we'll just look at the elements of quasi-recidivism, or the Article 160, which is titled Commission of Another Crime During Service of Penalty Imposed for Another Offense. So there are only two elements. Number one is the offender was already convicted by final judgment of one offense, and before beginning to serve such sentence, or while he is serving, while he is inside the prison, he committed a new felony. So this is your crimes against public order. So this is the end of the video, but before I do that, I would like to thank all of you who are subscribing to my channels, and please, if you can do so, please share it also to your other friends. Thank you.